Very good afternoon to all present. I am making this presentation on ethical issues in future development of AI. Thank you. So my presentation is ethical issues in future development of AI, and here I am presenting you very important areas which are of our concern. So, as we understand that the AI and machine learning technology has, dual promise. I mean, they are immensely important for the society, yet they can carry potential risk if not aligned with ethical standards and constitutional principle. So it is imperative to understand the AI development adherence to international norms and constitutional standards, safeguarding fundamental rights like privacy, equality, and freedom of expression. This balance is very important as far as ethical AI is concerned. If I discuss aligning AI principles with the constitutional standards, I must say that AI principle must align with the constitutional standard, anti-discrimination, privacy, freedom of speech, expression. And in many countries, the courts have been talking about what kind of legal framework is possible as far as the artificial intelligence is concerned. So AI governance framework must incorporate those broader constitutional principles to protect individual rights and liberties very, very effectively. I am just mentioning two very important books which have just come out. In anybody who is interested in the ethical aspects of AI, they must look at this two important books. So one is Reengineering Humanity by Brad Freshman and Ivan Selinger. The conclusion of his book is, which is on your slide, you can look at freedom from programming. The first important conclusion of this important work is freedom of from programming, conditioning and control engineered by others. In our modern techno-social world, we call this freedom to be off. So individuals should have this right while AI develops the freedom to be off. Means they should not be put under any kind of external control as far as AI is concerned. The second important thing is the freedom of will and practical agency. So in our again modern technical social world, we call this freedom from engineered determination. Freedom from engineered determinism means the engineering or science should not go too beyond to control human. That's why the title of this book was Re-engineering Humanity. So what kind of pitfalls and dangers are there for humanity is something this book talks about. Second book, which is not mentioned on your slide, I am referring you to please look at those who are interested in ethical aspects of AI. That is by a Australian law professor. His name is Toby Walsh. Toby Walsh talks about machine behaving badly, machines behaving badly. And this book gives a very detailed framework, including the risks and dangers which AI can create as far as humanity, society, and civilization is concerned. The third very important principle is the alignment of AI with ethical norms. As I have said, that AI requires design, adaptation, and training with context-driven database for effective and safe deployment. So contextualizing AI means the deployment environment is crucial for ensuring safety, privacy, accuracy, and reliability. So AI ethics need to be integrated into the governance because we are talking about AI governance through EU Act and all those things. Therefore, how ethics can be integrated with the law and regulatory framework. That is something which is very, very important. So, 5 key AI principles which support constitutional adherence and protection of user rights and liberties during development. So, I am just going to mention 5 important principles which are key as far as the ethics and AI is concerned. The first principle is principle of fairness, because AI is so important that at some point of time it goes beyond the human control, and therefore the database that you create, various biases including data set bias, data set bias. So at the moment chat gpt and all AI databases are using existing database which has already been created by group of people, which essentially carry certain bias and prejudice. So how we can protect ourselves from those bias and prejudice, especially they should not lead to exclusionary outcomes. So fairness in AI is multifaceted: non-discrimination, inclusivity, and equality. This is very important. So this is very, very important as far as this whole area is concerned. There are 2 important facets of fairness. Fairness can be seen in 2 ways. One is where we can look at equality. So AI must be a tool for social justice, offering equal opportunities and protection to all, thus fostering an equitable society. Because if AI deployment results into any kind of discrimination, inequalities are perpetuated, then the entire idea of AI will be defeated. So the guarantee of equal opportunity relies upon transformative power of AI system to help eliminate relationship of domination between groups and people based on differences of power. This is very important. Power, wealth, and knowledge. So the procedure and produce social and economic benefits for all by reducing social inequalities and vulnerabilities. Now, another thing relating to fairness is non-discrimination and bias, because we are using AI in a big way. But how we look at these discrimination practice and bias thing as far as AI is concerned. So there are speed definitions, there are feature selection, there are use of proxies for sensitive data, alongside international design choices that discriminate based on specific characteristics. So proactive bias identification and mitigation in AI system ensure equitable and fair outcomes for users. Now I come to a very interesting aspect which is called principle of safety. And I have said you I'm discussing 5 principles which are very central to the ethical framework of AI, because you will see in next couple of years all the countries in the world will have their laws on AI regulation, but these laws should be guided by certain principle. So I am talking about responsible AI, I am talking about principled AI, and therefore principle of safety and reliability is very important, because safety and reliability concerns in AI system include issues such as unfair and discriminatory outcomes, unethical use, challenges in explainability and transparency. An AI system must operate safety and reliability with robust mechanism to prevent unforeseen risks. And similarly, if you see the level of human oversight in AI should correspond to the system sensitivity. So at the moment, we are finding human oversight is largely missing, especially in many cases where we see metaverse, or where we see autonomous vehicle, or where we look at all other kinds of gadgets and applications. So establishing comprehensive assessment system for continuous evaluation of AI systems impact and legal compliance is vital. And certain AI systems, once deployed, continue to develop and learn from their experience, assessment, and could be a combination of self-assessment and assessment by expert. So this is three-way process, ensuring intended operation, human oversight, and adopting the assessment and systems. Now, this is the most crucial principle as far as the use of AI is concerned, because privacy is a very important and central human right and can be found in several international law instruments such as Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. So it's a very central as far as AI is concerned. So addressing privacy considerations in AI development, including adopting privacy by design. I'm using this word privacy by design. This is very important and crucial for safeguarding. What is this privacy by design? So probably we cannot mitigate all the concerns of privacy in a very simplistic terms. So therefore, there is an idea that the applications and gadgets should be created in a manner where privacy protection is made inbuilt in that technology. So there is no need for any external arrangement to be made. So privacy by design integrates privacy and security from the outset of the product design. At the time of design, this can be created. An operation making privacy as a default setting. Privacy as a default setting. This is very important. Privacy at the moment is not a default setting. You have to give a lot of permission. You have to restrict a lot of application. But privacy as a default setting is something which is very, very important. Now, I'm coming to principles of transparency. Now, transparency is very important because black box effect requires clarity on AI and tools of internal operation ensuring AI ethicists have access. The goal of transparency is to ensure AI systems are non-discriminatory, fair, bias mitigating, and capable of generating public interest. So this is very, very important. I'm coming to a very important aspect. What are the key aspects of transparency and how we can operationalize transparency and what is the way to achieve? I'm not reading everything because it is before you, but providing stakeholders with meaningful information is important, and making AI system their decision-making process is again important. Developing explainable AI to ensure decisions are understandable to all stakeholders. Uh, can you imagine at the moment AI does not explain its outcome? So whatever output is given by ChatGPT or any other application to you, it doesn't explain why this output or why this answer is in a particular manner. So there is no clause of putting the explainability on AI at the moment. So we are contemplating future AI should be able to explain as to why a certain kind of explanation is being given. It may be due to the data set, it may be due to the research that AI is backing upon or any other condition. Now, principle of accountability is again very, very important because accountability in AI involves, because we are demanding now AI to be accountable. So European Union Act are laws that have been created in China, Hong Kong, England, and all other places. They are trying to put certain degree of accountability on AI. And therefore, the accountability in AI involves a clear assignment of responsibilities across the AI life cycle to address potential errors or advanced impacts. So lack of accountability in AI system complicates assigning responsibility for AI related errors, adverse consequences, or rights violation. So if tomorrow some mess happening takes place because of autonomous vehicle or driverless car, what kind of liability or what kind of accountability the AI will have? At the moment, the systems are struggling to consider whether AI can be held responsible for civil losses or civil liability or criminal liability. So whether there can be a criminal liability or a civil liability in case of any accident or any mishappening. Now this question for law students is going to be very, very important as to how the AI shall be or should be made accountable. Accountability emphasizes responsibility, answerability, trust across organization and other things. So clear identification of AI system, important phases are development, testing, and deployment, and making relevant stakeholders accountable for their specific contribution. Because unless this thing happen, it would be very difficult for the legal regime to put the AI into a kind of liability. This is very important. However, world over, there are two schools of thought. One is saying AI should remain autonomous and free, like human beings. On the other hand, there is a school of thought which emphasizes that AI should be subjected to reasonable restrictions and a regulatory framework. So both the things are very, very important. Toby Losh, in his book Machine Behaving Badly, has raised this concern, and therefore he is talking about it. But what are the stages of accountability? So if you see, pre-deployment accountability is very important because we have to engage with open source and academic communities for ethical design verification. So before you deploy AI, you need to ensure what are the ethical design verifications which have been made inbuilt in AI. Similarly, they implement a multi-stage audit process engaging open source, academic and research communities for algorithm reading. So, and during deployment also, continuous monitoring, continuous audit, and employing a scaled audit approach for AI system is very, very important. And similarly, the post-deployment accountability, where we wish to look at the enhancing of human oversight. So we are contemplating currently a system where there will be a human oversight mechanism to monitor artificial intelligence system. Without human oversight, the compliance of ethics is going to be very, very challenging. Because the two books which I have mentioned, they are raising a concern. And one concern Elon Musk has raised, which is very valid. He said tomorrow the biggest danger to the humanity is going to come from the robots. Robots are going to challenge the human existence in the society because robots are going to be very, very powerful. They would be very, very autonomous, independent, free thinking, more efficient than human being. So if they are given control of vital systems in the society, the stature of human being is going to be very, very crucial. Now, last, in the end, I would like to say the Google is the major player as far as advancement of AI technology is concerned. Even they have come out with these 7, 8 principles, which are very important. And entire AI technology advanced by Google revolves around these 8 principles, which should become the mainstay of any legal development. So be socially beneficial, avoid creating or reinforcing unfair bias, avoid creating or reinforcing unfair voice, be built and tested for safety, be accountable to people, incorporate privacy design principle of high standard of scientific excellence, and be made available for use and record with these principles. In the end, I would say we are looking for, as I have mentioned, responsible AI. We are looking at principled AI, and therefore emphasizing the shared responsibility among developers, regulators, and user to guide all deployment towards beneficial society outcomes, and also encouraging a collaborative approach to ethical AI governance that respects human rights, promotes fairness, and builds trust in AI technology. Thank you for your attention.
Sayın Profesör Bajpai'ye etik konusundaki bu giriş konuşması için çok teşekkür ediyoruz. Sizlerin de takip ettiği gibi önemli konulardan bahsetti ve öncelikle yapay zeka teknolojisinin insan kontrolü altında olmasını belirtti bize. Teknoloji gelişirken bu teknolojinin hukuk tarafından daha sonradan takip edildiği bilinmektedir. Önce teknoloji gelişiyor, arkasından da hukuk geliyor. Fakat bugün burada bu kadar çok değişik konularda tebliğler veriliyor, konuşmalar yapılıyor ama hepsinin içinde de hukuk var. Sorumluluk var ve insan var. Ve bu nedenle hukuk ve yapay zeka konusu zannediyorum ki en önemli konulardan bir tanesi. Belki biz de içinde olduğumuz için böyle düşünüyoruz. Şimdi ikinci konuşmacı olarak Sayın Profesör Putzke'yi ben davet etmek istiyorum. Herr Putzke, bitte kommen Sie. Kommen Sie bitte. Çünkü iki konuşmayı birden soru cevaba çevirelim. Daha hem zamandan istifade ederiz. Yapay zekanın Avrupa Birliği içerisinde kurallara bağlandığı bilinmektedir. Sayın Profesör Putzke bize yapay zekanın Avrupa Birliği içindeki kurallarını açıklayacak. Kendisini dinledikten sonra kısa bir soru ve cevap yaparız. Yansıtıldı mı yansıması? Profesör Putzke'nin. Would you also shortly introduce yourself before starting?
A very warm welcome. My name is Holm Putzke and I work as a professor at the University of Passau. Thank you very much for the invitation. It's a little bit noisy here, but I try to speak very loud. So I come from Bavaria and it's located in Germany, and perhaps you have already heard about it. Germans love rules, especially lawyers. This is precisely why I am the ideal speaker to present the European Union's Artificial Intelligence Act to you. When the EU began to think about artificial intelligence, many people still thought of artificial intelligence as being limited to translation programs, language assistance, images analyze software, search engines, modern robots, autonomous cars, drones, or Internet of Things applications. In 2018, these were still the buzzwords shaping the debate. Just 6 years later, everything looks very different. Just a year ago, many people had no idea what the term large language model, LLM, meant. A large language model has the ability to handle general language generation and other natural language processing tasks. LLMs learn statistical relationships from text documents during a training process. Well-known names and companies include OpenAI's GPT series of models, GPT-4 and Microsoft Copilot, Google's Palm and Gemini, or an AI model from the French company Mistral. But that's not all. After the large language models, the next development step will be the large action models, LAM. This is no longer about training with texts, but with data from cameras and motion sensors. If everyday objects are equipped with them, such as watches and fridges, LAMs will calculate what we will do next and react accordingly. The pace of development is rapid. Progress is reported almost daily and is expected to affect all areas of our lives. In the not too distant future, pessimists and optimists alike predict that by 2028, nothing will be the same with AI. Incidentally, this is also the difference between this and historical groundbreaking developments. The invention of the steam engine and the associated industrial revolution fundamentally changed production processes, but by no means affected all areas of life. It was no different with the discovery and use of electricity and the internal combustion engine. The breakthrough for the internet also lags far behind AI in terms of opportunities and risks. In terms of risk potential, there are also significant differences to the invention of dynamite by Alfred Nobel or the discovery of nuclear fission in 1939 by Otto Hahn, as well as the invention of nuclear weapons by Robert Oppenheimer in the Manhattan Project. Because not everyone can produce or obtain dynamite. Not everyone can build or own a nuclear bomb. Fortunately, not everyone has access to all of these means of destruction. But almost everyone can deploy and use AI. All over the world, companies are busy developing AI-based applications that can be used by almost anyone, anywhere in the world, including governments and the military, of course. The ubiquitous access to AI technology from providers of this technology and from users all over the world makes the technology both rich in opportunities and highlights the enormous potential threat. Combined with state and private surveillance through cameras and microphones in public spaces, using drones and autonomous systems, dystopian scenarios are already presenting themselves to the frightened observer. In a world where AI permeates everything and it is a matter of time before it is used in all areas from business and public administration to private life, the need to regulate these technologies is also increasing. The European Union has responded to this need by passing the AI Act. This is a law that aims to regulate the use of AI systems and promote innovation at the same time. This AI Act is not only a response to technological developments, but also an attempt to set ethical standards and protect the rights of citizens. We have heard about it in the speech before. Today, I would like to explain what the AI Act is, who is affected by it, and what its strength and weakness are. It asks whether it delivers that politicians promise. I will first go into this, what the AI Act means by AI. This is important. Then, who is the addressee of the AI Act? Then on the objectives and content. And finally, we will have a brief look at the United States and President Biden's executive order. At first, scope of application. What actually is an AI system? If I ask you, I think I would get different answers. You can read the definition in the AI Act. There is already a problem with this definition. It remains unclear whether and at what level of complexity more sophisticated rule-based systems also fall under the regulation's definition on AI. And this is not good for legal certainty. And it could also be hostile to innovation. The definition is very wide and everything could be AI. And this is a big problem for the European Union because as I mentioned it's maybe not good to have an invest in the EU if you don't know, is this rule for you or not? What is the target group? Who is the addressee of the AI Act? The AI Act primarily applies to providers. These are persons or entities that develop an AI or a general purpose AI systems, GPAI models, or have it developed and bring it to market or put it into operation under their own name or brand. Providers are covered if they place the AI system on the market or put them into operations in the EU or place GPAI models on the market regardless of whether these providers are established in the Union or in a third country. However, the regulation also imposes obligations on operators, deployers. It asks persons or entities that use an AI system under their own responsibilities. If they are based in the EU or are located in the Union, the usual linking of responsibilities to the country of establishment or domicile as well as the market location therefore applies. In addition, providers and operators of AI systems with an establishment or domicile in the third country are also be covered if the system is questioned, is not placed on the market or used in the EU, but the result produced by the system is used in the Union. The criticism immediately follows this description. The scope of application is almost limitless. It remains to be seen how this blatant ambiguity will play out in practice. What is the content of the AI Act? The primary objectives are, you can read it, improving the functioning of the internal market. It has harmonization by eliminating potential divergences in the member states' individual legislation. And the second goal is protection of those affected by AI who are established and resident in the EU. The AI Act is first and foremost a protection regime. In order to achieve these objectives, the AI Act primarily formulates legal protection requirements in relation to the development, marketing, and/or use of, the first is AI systems that are aimed at prohibited AI practices. This is Article 5 of the AI Act. Second, AI systems that are considered high risk. Surprising, so-called high-risk AI systems, Article 6. The third one are GPAI models, Article 51, and the fourth, certain other AI systems, Article 50. The reason for these restrictions is that data-based AI systems have a specific risk of error due to the way they function. This can lead to output that involve de facto discrimination on the basis of group-related characteristics, for example. It also usually not transparent how outputs are generated. To prevent this from happening, the AI Act set out requirements for the design, training, programming, and validation of the systems and the models on which they are based. Let's take a closer look to the protection requirements. Article 5 AI Act contains an AI blacklist of prohibited practices. This includes 4 groups. The first group, harmful AI systems are prohibited. This means that systems may not be placed on the market or used if they significantly influence the behavior of human, fraud, subliminal influence, or intentional manipulation or deception and or exploitation of a weakness or vulnerability in a way that can cause significant harm to them or third parties. The second, system that enables social scoring. It asks that lead to the disadvantaging or discrimination of certain persons or groups of persons, either in social contexts that are detached from the original context or data collection, or that are unjustified or disappropriate with regard to social behavior are prohibited. If you have a look to China, you can get an idea what does it mean to have social scoring. I've been in China several times, and the people there told me about social scoring, and it's scary. It's a scary movie, I can tell you this. The third thing is AI system AI systems for the analysis of highly personal characteristics, namely systems for predicting the commission of criminal offenses, for the untargeted reading of facial images from the internet, or surveillance recordings for deriving emotions in the workplace or in educational institutions, and for biometric categorization and are prohibited. And the fourth category, systems for real-time remote biometric identification in public accessible areas for law enforcement purposes are prohibited unless they are absolutely necessary in order to take certain exceptionally permissible investigative measures. I would like to say something about the criticism right away. The compilation is unsuccessful. This is because there are numerous exceptions to the last point on criminal prosecution at preventing danger. In addition, the prohibition contains numerous undefined legal terms. It is likely to be difficult to determine with legal certainty in individual cases whether a specific system falls under one of these offenses. Do systems with virtual reality environments, gamification elements, or dynamic price adjustments not work with subliminal influence? The requirement of an unjustified or disappropriate disadvantage or discrimination in connection with social scoring systems also opens up considerable scope of consideration. However, legal uncertainty hinders innovation and also prevents investments. While the prohibition in Article 5 AI Act is subject of various concerns, Article 6 places high demands on providers of high-risk AI systems. What does it mean? High-risk AI systems are systems that are used in areas in which the specific failure and or intransparencies of AI systems can have a particularly detrimental effect on the operator and or the person concerned, and for which specific requirements must therefore be formulated for the design, training, and modeling of the AI. This applies the following areas, for example, biometrics, critical infrastructure, education, employment, use of essential service and benefits, private and public, security and law enforcement, migration, and administration of justice. The AI Act takes a risk-based approach here. A system that are not classified as high risk, AI systems are, with a few exceptions, not subject to specific regulations. Anyone who wants to develop and use a high AI system needs a specific risk management system, must meet certain requirements for handling training, validation and test data, and must document the system's sufficiency technically, automatically, log events during the entire life cycle of the AI system, and ensure that system-related information about the system is made available to the operators. I can tell you and want to repeat it. The whole life circle, you have to make this documentation, the whole life circle. In addition, the AI Act makes high-risk systems subject to human control and requires a sufficient degree of accuracy, robustness, and cybersecurity. While the regulations of high-risk AI systems are largely successful, the requirements for systems with a general purpose, the so-called GPAI models, are almost entirely critical. There are two categories: simple GPAI models and GPAI models with systemic risk. Simple GPAI models are subject to certain documentation and transparency obligations, and there is an obligation to take precautions to comply with copyright law. GPAI models with systemic risk are those with particularly high performance. Here, the AI Act provides for compliance with additional self-monitoring obligations, including ensuring sufficient cybersecurity, but also the obligation to assess and mitigate possible systemic risk that may be associated with the development and use of GPAI models. This includes risk relating to serious accidents, the disemission of illegal, false, or discriminatory content, and the development of chemical, biological, and nuclear weapon. It is highly questionable whether providers of GPAI models can do this at all. Such self-monitoring obligations of the providers of GPAI models are boundless. It is simply not feasible for providers to assess and mitigate such diffuse remote risk. This has nothing to do with legal certainty. This was a rough overview of the content of the AI Act. What is the rest of the world, such as the United States, doing? Let's have a look. Let's have a look to the US, and there you can find a numerous of regulations in the individual states. The executive order issued by President Biden on October 30 in 2023 is particularly important. Although the executive order has no direct legal effect, its content and impact on the US and globally should not be underestimated. I will mention a few principles and key points by way of example. The principles emphasized include the safety of AI systems from malicious or willful misuse, protection of creators, consideration of employee concerns, duty to respect civil rights, and equal treatment concerns, protection of civil liberties, and primarily privacy. The executive order also contains numerous transparency and notification obligations. In summary, I can be said that even the US, as a typically innovation open and regulated skeptical liberal market economy, is increasingly focusing on the justification of ethical standards, hard rather than soft law, and the shift from self-regulation to external regulation. This brings it very close to the coordinated market economies in Europe. To summarize, there are three notable differences between President Biden's executive order and the AI Act of the European Union. While in the AI Act emphasizes sustainability and environmentally protection, in the executive order contains nothing of this regard. On the other hand, the AI contains nothing on social issues. How should the losers of the digital transformation be dealt with? You can find this in Biden's executive order. Biden's executive order also focuses on the promotion of AI capacities, which in combination with regulatory approaches should increase acceptance and at the same time alleviate concerns about the stifling of innovation. The AI Act excludes these aspects. Conclusion. Let me conclude. The German inventor Werner von Siemens is said to have coined the phrase, "He who masters the standard masters the market." The EU seems to be following this maxim and relying on the Brussels effect, coined by Professor Anu Bradford of Columbia Law School in 2012. This refers to the process of one-sided regularity, globalization caused by the European Union de facto shifting its laws outside its borders through market mechanism. However, it is questionable whether it will work. It is possible that the Brussels effect will replace by the Washington effect or the Beijing effect. Only time will tell which approach will ultimately be more successful in the digital age in finding a balance between openness to innovation to maintain progress and prosperity on one hand, and the protection of individual freedom and democratic structures on the other. And the future begins, which will come as no surprise for you after I have finished speaking. So now, thank you for your interest and attention.
Sayın Profesör Putzke'nin en son söyledikleriyle bir nokta koymak istiyorum ben de. Bir norm, bir standart olsun dedi. Standartlar olmayınca da teknik iyi çalışamıyor. Hukukta da bir düzenleme var. Birisi bir şey keşfediyor, bir tüfek keşfediyor, otomobil keşfediyor. Fakat silahın nasıl kullanılacağını, otomobilin nasıl kullanılacağını hukuk belirliyor. Bu teknoloji kullanılırken insanlara zarar vermemesi gerekiyor ve insanların kontrolü altında olması gerekiyor. Her iki konuşmacı da buna değindiler ve teknolojinin etik ile bağlantısını önce Sayın Bajpai ortaya koydu ve bu teknolojide mutlaka ön yargı olmamasını vurguladı. Çünkü insanların ön yargısı teknolojiye de yansıyor ve verdiği kararlarda ileride bunu yansıtıyor bize. İkincisi güvenlik olsun, güvenilirlik olsun dedi Bajpai'nin konuşmasında ve insan denetiminde olmasına önem verdi. Ve mutlaka teknolojinin insan kontrolünde olmasını, bu kontrolün mutlaka sağlanmasını vurguladı bizlere. Fakat teknolojinin aynı zamanda özel hayata müdahale etmemesi gerektiğini belirtti. Çok sayıda toplanan kişisel veriler ileride analiz edildiğinde ne yapacağınızı bize söylüyor. Ve Sayın Putzke'nin de belirttiği önemli nokta bu. Önce bir tercüme makinesi diye başladığını söyledi. Kelime üzerine çalışan prosesler, fakat daha sonra hareket üzerine başladı. Ve hareketleri analiz ederek ileride ne yapacağınızı size öngörebiliyor bu yapay zeka. Fakat bunun da insan denetiminde olması gerektiğini söyleyen Avrupa Birliği'nin kurallarını bize yansıttı. Ve çok önemli bir şey söyledi. Bazı teknolojilerin yasaklandığını belirtti Avrupa Birliği içerisinde. Özellikle yüz tanıma sistemlerinin yasaklandığını söyledi. Fakat yasaklamanın da tamamen yasaklama şeklinde değil, polis hizmetlerinde, adalet hizmetlerinde kullanılmasının kurala bağlanması, belli alanlarda serbest bırakılabileceğini söyledi. Ve bu önemli şeyler içerisinde dediğim gibi en son söylediği çok önemliydi. Teknolojinin bir standarta bağlanması gerekiyor, kurallara bağlanması gerekiyor. O kurallar içerisinde çalışırsa ancak bize faydalı olabilecek. Şimdi iki tane soru almak istiyorum. Bir tane Sayın Bajpai'ye, bir tane Sayın Putzke'ye. Zaman epey ilerledi. Diğer toplantıdan geç başladık. Zamanı biraz yakalayalım diye fazla soru almadan iki tane soru. Bir tane soruyu alalım. Kime soruyorsunuz? Evet, Sayın Putzke'ye bir soru var. Bir de ikinci soruyu da gördüm. İki soru sadece.
Hello, Mr. Puskin. Welcome again to Turkey, first of all. I want to ask you about the AI Act. Do you really think that is it applicable for the whole of the European nations? Because as a developer of AI and a legal person, can you hear me?
Oh, it's very noisy.
Can I come here? Can you hear me right now?
Yeah.
Okay. Do you really think that the AI Act is applicable for the whole nations of the European Union? Because as a developer of AI and the legal person, for me, I really saw that it is hard to understand and it is not logical for us to ban the whole system as high risk, because even us, we don't know are we in the high risk situation or not. What do you think about that? I think it's not an acceptable thing for us.
Yeah, thank you for this very important question. And a part of the answer I gave in my speech, I said the AI Act is unlimitless because you have a lot of non-specific words, and so it's not possible if you are an operator or a provider to get an idea if your tool is a high-risk AI or not. And so you can try it, and maybe somebody will come from the European Union and punish you. The problem is you have in the AI Act you have some sanctions and of course criminal rules, but we will see how it will work, because all the member states of the European Union, they have to involve these rules in their own legislation, and I have no idea how long it takes. Maybe 1 year, 2 years, or something like this. Maybe 4 or 5. Maybe Poland is very fast, but Germany is very slow, and so I have no idea. The idea, of course, is nice to say we have 27 member states, and in every member state is the same level, and everybody knows about it. And of course, this is a nice idea. And this is also the base for the European Union. And it worked since 40 years quite well. Yeah. But I'm not sure if you can regulate a topic which is so fast developing. And so law is very static, and AI, of course, if you take the steam engine, we have rules, they are 100 years old, and they still, okay, yeah, it runs fine. And also with a nuclear bomb, yeah, of course, very, very, it works. So, but AI, what we have today is tomorrow snow of yesterday. I don't know if I can translate it from German. Snow of yesterday in English. Snow. And so I'm not sure if you can regulate this and you put it in a very, very hard structure. We will see. Nobody knows it now. But what is the alternative? To do nothing? No. I'm not sure. I'm not sure if this is the solution. But we will see in 2 years, in 4 years, what will happen.
Bir şey dikkatinizi çekti mi Avrupa Birliği'nin bu kanunu içerisinden? Amaç nedir? Amacı söyledi Putske bize. Amacı olarak da şunu belirtti. Dedi ki ticareti korumak. Avrupa Birliği içindeki ticareti korumak için yapılıyor bu dedi. Ticareti korumak için bir kural koyuyor. Ve yine zarar vermemesi için de, ticarete zarar vermemesi için kural koyuyor. Avrupa Birliği'nin yaklaşımı biraz farklı. İkinci soruyu alalım. Buyurun siz ikinci sorunuzu sorun. Mikrofonu alalım yine.
Hello. My question is to you. I would like to draw a parallel between this European Act and GDPR, and the GDPR construction, the regulation on data protection. When we regulate data protection in Europe, it was a continuation of Budapest Convention, okay? And it gave exactly the same pattern. America with soft power, Europe with hard power, and you know the result, it's resultless. Artificial intelligence, you wanted to start from scratch, and it was inspired by the European Directive on Defective Products. And it's still under construction. I think the parallel is very important because it's something that you cannot regulate by construction because it goes very fast. It's digital. This is number one. Number two is because you cannot have arbitrage between United States where it encourages and it not break the pace and Europe when you want to over-regulate. So this arbitrage is ineffective. So as far as I'm concerned, I think that when you said, I don't know, shall we do nothing? I think we should govern through soft rules. And my problematic here is we are in Turkey today, and it's gonna develop in Turkey artificial intelligence, and Turkey as a state has to take a position. And my recommendation would be more toward the American construction and mechanism to give like a nice artifact impulsion to this industry rather than to over controlling in Europe with no result. This is I would like to share this point with you.
Yeah, thank you very much for your comment. So I totally agree with you. And so we have in Europe and the US a completely different product law. So and the sanctions. In the US, it's like, okay, you can create a product, and if it goes wrong, okay, we will kill you. Yeah. So this is in US, and in Europe, is it? Oh, if you will create a product and give it to somebody else, we have to prove it very, very long, yeah, several years, and it makes it expensive. And maybe this product is old after this process. So, and nobody wants to have it. Yeah, yeah. So, and so this is completely different. And so maybe the US system is for AI better. Maybe. I think so. Could be.
Ben her iki konuşmacıya da teşekkür ediyorum ve kürsüyü ikinci tebliğ için Sayın Profesör Zafer Kahraman'a bırakıyorum. Hepinize teşekkürler.